Thanks once again. Thanks everyone for being here. Esteemed delegates, observers, friends of UNCITRAL Working Group 5. On behalf of III and my firm Akerman, I'm very happy to welcome you to this program, the intersection of maritime law and insolvency. I'd like to thank the Secretariat for attending. I'd also like to thank Evan Zucker and CC Schnapp for helping me plan this event. III values this long-standing partnership with UNCITRAL and the work achieved at Working Group 5. III and its members who participate not just as members of many NGOs, but also as official state delegates, have participated eagerly in the working group for many years and are thrilled to continue contributing to the important work of this group. I do want to remind III members about our annual conference in Brazil. Still time to register, so please do that. Most of you know there's a bar in the back, and we will have food available after the presentation. Now, it's my pleasure to introduce Olya Antle as the monitor for the panels. She's an attorney at Cooley in Washington, D.C. I've been with her on multiple Working Group 5 delegations and III projects, and I'm just delighted to have you as the moderator. I'll let you properly introduce your panel.
Thank you so much. I hope that everyone can hear me. Good evening. Welcome to Navigating Troubled Waters, Charting the Course Between Maritime Law and Insolvency. It is my privilege to steer today's conversation. Over the past decade, our shipping and restructuring worlds have collided more often, and at times, perhaps not as gracefully as we would have hoped. Admiralty's ancient in-ram arrest and privileged maritime liens can sit uneasily beside the UNCITRAL's model law's vision of a single, coordinated insolvency estate. The result brings up some practical questions. Should the automatic stay ever yield to a ship arrest? Where is the comey of a one-ship company that flies a flag of convenience but is managed from a third jurisdiction? What is the context, implications, and current status of the Beijing Convention on the international effects of judicial sale? Our panelists will tackle these issues, which may need further consideration by our working group as we move forward with Australia's proposal calling for a comprehensive update of the Guide to Enactment and Interpretation of the Model Law on Cross-Border Insolvency. So against this backdrop, please let me introduce today's panelists who will be navigating these waters and helping to set a clearer course for courts, creditors, and the debtors worldwide. To my right, I have Warren de Waegh. Warren is commercial law lecturer and PhD researcher at the Erasmus School of Law in Rotterdam, the Netherlands. Next to Warren, we have Michael Schaedle. Michael is the partner at Blank Rome in the firm's finance and restructuring practice. Mike is one of the firm's leaders in maritime restructuring, representing foreign representatives, lenders, maritime creditors, and creditor groups. Kai-Yun Tan is next to Michael. And Kai-Yun is a partner at Wang Partnership in Singapore in the firm's restructuring and insolvency practice, focusing on shipping and maritime law. Welcome to all. So to start, I would like to ask that each of the panelists please weigh in on the core friction points between Admiralty and insolvency. Mike, let's start with you. Maybe you can help us set the stage with regard to how the U.S. tariff-driven trade policies are reshaping the insolvency risk calculus for the maritime clients that you advise.
Thanks. The imposition of import taxes and related charges is creating a great deal of volatility and uncertainty. So we've seen an increase in traffic in terms of inquiries regarding. Can't hear me? Can you hear me now? All right. Okay, now it's spectacular. Okay. So we've had higher traffic in inquiries about maritime risk and restructuring that reminds me, at least, of the last cycle, which terminated around 2016, 2017 in terms of high volume maritime restructuring. And so why is this? Well, there are really two externalities that are creating the volatility. Obviously, you guys are all aware of the tariff environment, which is creating a grand level of uncertainty relating to pricing, production in various markets, all of which are served by shipping interests. And that is a common problem across
different shipping sectors. And at the same time, we also have regulatory changes that are being implemented in Washington relating to the surcharging of particularly Chinese-billed shipping, so that if you are a ship owner whose vessel is coming into the United States and trading and it's a Chinese build, you're subject to additional charges. All of those things are creating wide uncertainty as to all sorts of different kinds of decisions that shipping and shipping related firms have to make. The most obvious is pricing service, but you also have decisions that you have to make about a shipping line's effective inventory, right? You know, the pacing of build and where you do it. So if you have significant investments in builds in Chinese shipyards, you have to reconsider the tempo with which those projects are completed and whether or not investments need to be made in other yards. And you're doing this in a political environment that is, again, unpredictable. As you all know, as restructuring professionals, our commerce hates volatility and unpredictability when it comes to making mid and long-term investment decisions. And so when I see all of this and I sense that the traffic that's incoming and the questions that are being asked of lawyers like me and Kayun by our clients is reminiscent of the last storm surge, if you will, in restructuring, I always go back to the importance of understanding the tools in our toolkit to enable collective remedies, and the importance, particularly when we're talking about international business like shipping and related niches, of having a properly functioning international system where ancillary and plenary proceedings can interact both through the offices of the model law and appropriate protocols to make certain that decisions are made that fulfill the basic policy behind restructuring laws almost everywhere, which include social goods like enhancing employment, rehabilitating capital, and the like. And so this is something that I'm acutely aware of when I'm dealing with maritime restructuring because of the strength of the admiralty law and the jurisdiction trapping fictions that accompany it. And oftentimes that creates, I hope, creative tensions in coming up with solutions for maritime clients. And so I'm delighted to be here to talk about these issues because I think we are coming on to a phase potentially where thinking creatively about those tensions is going to be super important for the folks in this room.
So speaking of those frictions and tensions, Warren, what are the peculiarities that make a maritime insolvency different from an ordinary corporate failure?
Thank you, Olya, and thank you for having me here. So, of course, the difference between any regular structuring, any regular cross-border insolvency, and maritime insolvency and insolvency of shipping companies in particular is the presence of the ship and the special nature of the ship as collateral that needs to be administered in a maritime insolvency, in international insolvency. And the ship is the central player in a maritime insolvency. Of course, for the debtor, it is its main means of production. It generates revenue for the debtor. And at the same time, it is a very valuable form of collateral for the creditors of the shipping company. But besides being a valuable and strong form of collateral, it is also a rather volatile form of collateral, given its international mobility and always traveling nature of the ship. And with the ship also comes, as it were, in the trail of the ship, an entire field of law that Mike already introduced us earlier, the field of admiralty law, which is specifically designed to enable, facilitate, encourage maritime trade and protect certain crucial maritime interests, maritime creditors, accommodating for this special nature of the ship as collateral. So within that context, I think there are three main issues that are distinctive for a maritime insolvency. First of all, there is the issue of COMI. So, of course, that's an issue that plays a role in many international insolvencies, but comes particularly to the fore in the maritime insolvency, given the complex corporate structure of shipping companies where ships are often placed in SPVs, special purpose vehicles, single ship companies, with each ship having their own legal entity, ships being registered in different flags of convenience where ship owner has little ties to, such as, well, the most popular ones are Panama, Liberia, the Marshall Islands. Ship management companies, perhaps in Greece or in other countries. So designating the center of main interest of a shipping company is quite a challenging endeavor. Secondly, in order to ensure the efficient, expeditious operation of the ship, the ownership, the management, and the control of the ship are often divided between different interests, different ship owners through different chartering agreements, financial leases of the ships through bareboat charter, hire purchase agreements. So also asset retrieving and retrieving which assets actually belong to the insolvency estate and which are subject to the insolvency moratorium is a second challenging task in a maritime insolvency. And thirdly, the administration of maritime liens, and as we will discuss later, I think that's the hardest nut to crack. Let's say in the maritime insolvency, maritime liens are a very specific form of security on the ship, a very strong form of security that is granted to specific maritime creditors. And because of this special nature of maritime liens, there is much uncertainty on where they fall within the administration of an insolvency. What makes it even more challenging is that there is great international diversity on which particular claims are accorded maritime lien status. So the countries like the US almost give maritime lien status to any claim arising in the operation of the ship, while English law is way more restricted and only grants it to salvors, collision claimants, and seafarers. So there is this international diversity in the recognition of maritime liens, but then also in the priority ranking of these maritime liens. So the sui generis nature of maritime liens, their international diversity in recognition and in the priority ranking creates a lot of uncertainty in their administration of maritime insolvency. So I think that are the main specific issues that arise in the maritime insolvency.
And Kayun, is there also a philosophical distinction between insolvency and maritime law that adds to that friction?
Okay, well, thanks, Olya. I would just want to start with explaining that fundamentally, although we always describe insolvency law and admiralty law to be clashing fields in their own right, fundamentally, they are both concerned with getting creditors' payment, just that they approach it in a different way. So for insolvency, it's really about finding that one single forum where you can distribute assets, collectively in an orderly manner. Admiralty, because of the mobile nature of the ships, like what Mike had mentioned earlier, there is that jurisdiction trapping mechanism, and that is to allow the creditors to be able to arrest the vessel in that jurisdiction so that you get access to that asset. So in a way, insolvency moves towards that one single forum, whereas in Admiralty, the creditors are able or even encouraged to choose between the fora that gives them the best possible outcome in an arrest. And that is because in various Admiralty regimes in the world, there are huge differences in how a claim can be regarded in a judicial sale and arrest. There's certain things like if you're a necessaries man or if you are a bunker supplier. In the US, you could be regarded as a maritime lienee that ranks above a mortgagee. Whereas in Singapore, you will be ranked after the mortgagee and only entitled to what we call a statutory lien. And even the question of whether these liens despite the name, whether they are considered security interests, that will differ from jurisdiction to jurisdiction. So because of all of these differences in the various admiralty regimes, you will see maritime claimants able to hedge between different jurisdictions. So there is that philosophical difference in that. If you think about it this way, in maritime, you move away from a center, you go to that one forum that benefits you alone in priority to other claimants who could have otherwise accessed that same asset. Then the other thing that I mentioned earlier on in terms of the mindset differences between admiralty and insolvency that I feel might be relevant to all of you, for all of you to know, it's that in insolvency, of course, we have our usual waterfall. You look at secured creditors first, followed by unsecured, and the usual priorities. In admiralty, that is different. The way that claims are ranked is based on the importance that it attaches to the ship. For example, the crew. For example, if you have a claim for damages resulting from a collision, all of these claims are ranked above a financing claim like a mortgage. So that is how, if you look at it differently, the substantive rights attached to each of these will make a difference in how a maritime claimant would choose to resolve the dispute.
One note, by and large, maritime liens are secret, other than preferred vessel mortgages. And oftentimes the priority, depending on the legal scheme, is in inverse order to when the claim arises. And so the fact of this secrecy and its at times opaque nature makes the lien and claim scheme an ill fit for many collective remedy schemes which are based upon blue sky and enable people to make financial decisions with a higher level of clarity about capital structures and what they mean. And so this is oftentimes a source of frustration for newbies in financing the industry or thinking about acquisitions of vessels in disposition contexts.
Sorry, just to add to that, the other thing to note is that for the maritime liens, they do survive a change in ownership. The only thing globally that can cleanse a ship thoroughly of any of these secret maritime liens is a judicial sale. And that's what we will touch on later on when we talk about the Beijing Convention. But think about it this way, when we do our schemes, when we have a 363 sale, all of these sales, the effect of that sale might be that it is not clean in the way that you understood it to be. Because if there is a maritime creditor in another jurisdiction that considers itself not bound by your insolvency sale, they could technically go ahead to arrest when the ship calls in that jurisdiction.
I think to summarize what Kayun and Mike has just said about maritime liens, I always like to use two ways of describing shortly what a maritime lien actually is. And one is a citation of the US Standard Handbook on the Law of Admiralty of. Okay, can you hear me? Yeah. Okay, so that's the Law of Admiralty by Gilmore and Black of 1975, where they start the chapter on maritime liens with a statement that the beginning of all wisdom in admiralty law is that a lien is a lien, but a maritime lien is not. So that really talks about the special nature of a maritime lien, and then also as to the fact that the maritime lien survives change of ownership and the strong form of security that the maritime lien is. I like this metaphor of an invisible cloud that essentially follows the ship wherever it goes, which can lead to quite a serious storm when the maritime lien holder actually enforces maritime.
Thank you to each of you for setting this up so nicely, because I will say that for us land lawyers, a lot of this is very counterintuitive. So if the working group reopens the guide, I think there will be a query as to whether a shipping debtor's commi should ever default to the place of incorporation. Do you think that there should be any changes to the presumption of commi for shipping debtors? And also, what objective indicators would you recommend to locate commi for a shipping debtor which may have hundreds of SPVs and vessels flagged under various flags, including flags of convenience. So let's start with you, Kayun, and then maybe Warren and Mike, you also weigh in.
Thanks, Olya. So the conventional wisdom for why shipping companies are often organized in this way, where they have multiple SPVs, each holding a single vessel, is not just for tax reasons, but is really because of the concept of a sister ship arrest. So for those of you in this room, this idea came about after an arrest convention, I think in 1952, where it allows a maritime claimant to go after not just an offending ship that is the subject of an in-rem claim, but any other ship that is held under the same ownership. So as a result, today, if you look at your shipping companies, everyone organizes that, most of them anyway, they organize their vessels in multiple SPVs to reduce the risk of sister ship arrest. But because of the prevalence of such structures, everyone understands also that the place of incorporation for every SPV, it is not necessarily tied to the economic activity of that particular company. The flag could be somewhere else. The place of incorporation could be in Singapore, and then the flag could be in Panama. This is a very common structure. And oftentimes in a group of shipping debtors, you will have a single group that is in charge of management, that they have ship management services, they provide the crew, they look at insurances and repairs. So that's how we all understand the commercial reality of every shipping debtor group. So rather than changes to the main model law on cross-border insolvency, I thought that the later model law on enterprise, on group enterprise insolvency is probably the better starting point for us to look at it. So I think in terms of whether we should change the presumptions of COMI, I don't think so. I do think that the established framework of how we analyze COMI could still apply. So in Singapore, we do have a recent decision, I think in 2023, where it applied a similar analysis to a Japanese group where they had 19 SPVs, and there were different jurisdictional factors pointing at different fora, but ultimately the court recognized that actually the business was run out of Japan, and that was how the court recognized that would be the COMI. So I think that the existing framework does already work, but if we were to tweak it and look at the guide, probably we have to look at it from the lens of a group enterprise insolvency.
Yes, I agree with Kayun that the new model on enterprise group insolvency would be particularly helpful for the administration of a maritime insolvency in general. Then as to the center of main interest of shipping companies under the current regime of the model law, I think that the presumption of the registered office should be given a lot less weight in case of maritime insolvency, given that, well, as we discussed, ships registered in flag of convenience have little or no ties to the jurisdiction. So no one in the right mind would want insolvency proceedings to be opened in these flags of conveniences. But I think it's also important to note in the EU context, where the presumption of the registered office under the European Insolvency Regulation has been interpreted rather strictly. So it has been quite hard to rebut the presumption of the registered office after the famous Eurofood case. But even despite this strict presumption of the registered office in the EU, there have been cases where, in case of a maritime insolvency, that presumption has actually been rebutted. There was an English case of 2015 before Brexit, where similarly as to Kayun's case, but then the ships were all registered in Cyprus, but little to no ties to the flag of convenience, in that case Cyprus. So then the court ultimately decided to shift the center of main interest to the actual center of main interest in the UK. So I would encourage courts to continue to take the center of main interest, the presumption of the registered office with a grain of salt in case of a maritime insolvency.
I'm in screaming agreement with the panel here. One of the things that you'll find when you do maritime law, and you already heard it in Warren's recitation of the handbook from 1975 is this tendency to poetry and a sense of exceptionalism. And sort of the image of a clipper ship sort of seems to like go through everybody's mind when they're thinking about these things. And the truth of the matter is that most shipping businesses, particularly liners, tankers, are organized around basic flows of capital in their business. Oftentimes they're thinly capitalized. And they're far from the only propco, opco structures that we run into. We see this in real estate. We see it in senior care. We see it in ONG exploration. We see it wherever there are specific risks that need to be isolated to a particular silo. And so you often will find questions of where one is going to file a case, where one is going to send a restructuring activity, whether it's a question of eligibility, whether it's a question of COMI, whether it's a question of venue, all relating to complex issues for entities whose center of gravity is hard to determine. And so I have to say there's nothing new under the sun oftentimes. And I always reflect back on the law of eligibility in Chapter 11 and some of its roots. And this is one of my favorite stories about that. It has nothing to do with time, but it's kind of fun. So once upon a time, there was a really unexceptional heavyweight champion named Primo Carnera. Primo could barely speak English. He was very Italian. Didn't do terribly well when he ran into serious opposition, but managed to be, through luck and mischance, the heavyweight champ for about 8 years. And during that 8 years, he lived really well in a hotel in New York. And eventually, he did so well in terms of his lifestyle that he had to file bankruptcy. And he filed bankruptcy under the old act. And there was a serious issue as to whether this Italian citizen, with his home, where his wife was living and his kids in Italy, could raise an American bankruptcy. And it was found that he could, because he had certain property, cash mostly, in his hotel room where he stayed reliably when in New York. Okay, so why do I tell that story? It's because the light footprint of maritime businesses is not an unknown thing to bankruptcy law in the United States or anywhere else. This is something that bankruptcy judges have to deal with frequency. And it is, in fact, why you have the registered office exception in 1516C of our Chapter 15 and in the model law. And why it's a rebuttable presumption, and why Judge Wiles recently in the Meganuco case, which was a balance sheet restructuring, in finding the COMI of an entity formed solely for the purpose of engaging in the restructuring activity at issue in that Chapter 15 and a related UK scheme of arrangement, found that in this context, where it's a balance sheet restructuring endorsed by all of the major creditor constituencies, the finding of the COMI for something called, believe it or not, Meganuco in the registered office in London was fine. But that he retained the power in determining COMI to look for abusive practices that would not be in the interest of creditors or that would be resisted by creditors. And I think oftentimes we should rely on the discretion of bankruptcy judges and restructuring and insolvency jurists worldwide to make these kinds of nuanced decisions about where the center of gravity for a main proceeding should lie. And that's particularly true when we're talking about the wandering maritime industry.
Very fair. So let's pivot a bit and discuss the treatment of maritime liens in cross-border insolvency situations. And Mike, we're going to go back to you from the U.S. perspective. What are the unique features of maritime liens and other encumbrances, such as statutory liens, on vessels?
Sure. So the maritime liens I know about are with particularity are U.S. maritime liens. I'm in lawyer. Don't call me to tell you what the English law is, for example. I've got friends that can, but basically, I think it's important to start with basics. So the maritime lien scheme in the United States is based upon a statute that was passed notably in 1988. It has deep roots in the poetry that I refer to. And by the way, I'm going to read you some of it. It's just so good. But the actual scheme, we call it CIMLA. Let me make certain I have the Commercial Instruments in Maritime Act, scooped up all of the various different elements of the lien scheme as to vessels, the Ship Mortgage Act, and a very developed body of common law derived from the English common law relating to maritime liens, and created a structure which, as Kayun accurately said, is very generous in according maritime lien position potentially to maritime creditors. And the basic idea behind this is that a maritime lien is a non-possessory right in a vessel that gives a lien holder the right to proceed in rem against the vessel. And this is based on the fiction that Kayun referred to as the personified vessel. It's a very old idea. And here's the poetry. In 1902, our Supreme Court waxed as follows. Again, no doubt Justice Brown had an image of a lovely clipper ship. He said, quote, "A ship is born when she is launched and lives so long as her identity is preserved. Prior to her launching, she is a mere congery of wood and iron. In the baptism of launching, she receives her name. And from the moment her keel touches the water, she is transformed and becomes a subject of admiralty jurisdiction." Tucker versus Alexandrov, 183 U.S. 424, 438, 1902. If you want to look it up. And I immediately put next to that a cautionary note from a great bankruptcy judge, actually a great appellate jurist, Judge Easterbrook from the Seventh Circuit United Airlines case. And he said, quote, in considering the character of a very complex aviation sale leaseback, it is unlikely that the U.S. Bankruptcy Code makes big economic effects turn on the party's choice of language rather than the substance of their transaction. So one of the things that creates this tension is this wonderful poetry of the personified vessel. And in focusing on that, oftentimes when you start injecting the idea of a collective remedy, you can lose to some extent the broader picture of where this siloed vessel sits within a capital structure or in a business organization. But under the Tucker fiction, a vessel is considered to be a legal person separate and apart from its owner and operator, and can be held liable for torts and contractual obligations. And a maritime lien claimant may file suit in rem and have the court in admiralty, the federal district court here in the United States, order the arrest of the vessel to secure their claim. This is important, folks. The arrest is the thing that renders the lien attached. It is the thing that creates the collateral. Before that, just an unsecured creditor. So as I mentioned, CIMLA, maritime liens arise from torts, contracts, or particular maritime services such as salvage, general average, towage, a bunch of other things. If you'd like me to, I can spend a half an hour talking about that. I won't. And this includes a variety of specific claims that are given a right of preference primarily over preferred ships mortgages, which are otherwise the dominant value catcher in connection with a vessel if they have been reported with the National Vessel Documentation Center. So the preferred maritime liens are liens arising prior to the filing of the vessel's been arrested for wharfage, then there it is. Damages arising out of a maritime tort, stevedore's wages, seaman's wages, general average or salvage. The only note I will give you non-maritime folk, except for sites here, on average or salvage is that it results very much from one of the things that can discharge
a maritime lien, and that is the destruction of the race or the partial destruction of the race. So under Admiralty law, the primary means by which maritime liens are discharged are through a judicial sale. And this is almost uniform in all of the various different systems. And so when you arrest the vessel under the Admiralty law, the vessel itself becomes in custodia legis, which is a Latin phrase that basically says that it has become under the specific tutelage and jurisdiction of the Admiralty Court. And it is as if the right to dispose of, not as if you're outside of bankruptcy, but it is as if the right to dispose of the vessel now belongs to the process that is pending before the district court. And in fact, the real splits in the law over maritime and admiralty jurisdiction in the United States and the bankruptcy power come up over this concept of in custodia legis. In the Ninth Circuit, quite recently, in 2018, in the Barnes versus Sea Hawaii rafting case, the in custodia legis doctrine, which had been, shall we say, largely in abeyance since the passage of the bankruptcy code, was revived. And a maritime lien enforcement action was said to trump the process of a trustee in bankruptcy. Cites is nodding his head sadly. And I can tell you that in the Hellenic Lines cases here in the Second Circuit, in the LaBeouf case, almost immediately after the passage of the bankruptcy code, the in custodia legis doctrine, which is a function of this beautiful poetry that I read at the top of my remarks, has been held to be trumped by the bankruptcy code. And indeed, I again go back to the fact that our SIMLA was enacted 10 years after our bankruptcy code and says not a word about the general power of the court and its enormous related to jurisdiction as identified in the Celotex case. And so when we talk today about this tension, we're going to be talking about maritime liens because it's at the heart of managing those liens that you find the greatest tensions. And in fact, you'll hear from Kayun and from Warren about exceptions in the EU, in Australia, in Singapore, that protect maritime lien claimant rights in a way which the US law does not do so, or at least does not clearly do so.
Yeah, let's turn to that. So one key issue that we see in every downturn in the shipping industry is whether maritime liens should be carved out of the moratorium protections and be allowed to proceed to arrest. So Warren, can you please weigh in? Should there be a carve out for maritime claims from the moratorium?
Sure. It's working, right? Is it?
No,
Okay.
I don't think so. Sorry.
Thanks. Okay. Maybe just a short addition first on what Mike has just said. It is important still to remember how diverse the field of maritime liens is internationally. So what applies in the US certainly does not apply under English law or under the laws of EU member states. As a matter of fact, there have been quite some harmonization efforts over the course of the 20th century, first in 1926, then in 1967, 1993, with different maritime liens and mortgages conventions trying to harmonize this field of law with diverging success, but overall limited success for all of them. So that really showcases how diverse this field of law is, and specifically in relation to which kind of claims are accorded maritime lien status. In general, however, I think that all legal systems agree on certain protection mechanisms that underlie maritime lien security, such as the priority over ship mortgages and claims of ship financiers. the fact that maritime liens arise by operation of law. There is no registration necessary. There is no other requirements for maritime liens to arise. They always arise by operation of law. And the fact that they also survive a transfer of ownership. So within that context, because of these strong protection mechanisms offered to maritime lien holders, as Mike introduced, there are several jurisdictions that have enacted the model law with a specific carve-out, an admiralty carve-out for maritime liens, or even broader, as Kayun will discuss later, for admiralty claims in general. And I would also like to draw your attention to the treatment of maritime liens under European insolvency regulation. So there is a consensus across EU member states, perhaps with the exception of the Netherlands, but there is still some uncertainty there, that maritime liens actually fall under the protection ground for rights in rem. So Article 8 of the European Insolvency Regulation. Courts have accorded this territorial carve-out protection to maritime liens under Article 8 of the European Insolvency Regulation across EU member states. Then the question, of course, is should there be such carve-out for maritime liens more generally? And of course, I think, first of all, it's important to stress that such carve-outs should be handled cautiously, and that they might affect the collective administration of the insolvency, of the restructuring. But there might be certain grounds as well to allow such a territorial carve-out for maritime liens. First of all, as I mentioned, there is this very strong protection mechanism accorded to maritime liens. So in accordance also with that exception for proprietary security rights, for rights in rem under the European Insolvency Regulation, therefore the legitimate expectations of the secured creditors, a protection ground is granted to enforce the secured claim directly on the assets. So within that context, a specific territorial carve-out for maritime liens could be justified in order to protect the legitimate expectations of maritime lien holders specifically. At the same time, and maybe even more importantly, I think that a carve-out for maritime liens, besides protecting maritime liens themselves, could also be a useful tool to improve the chances of restructuring. So it would be of benefit not only for maritime lien holders themselves, but also for the debtor, for the ship financier, and for restructuring efforts in general. And the reason for that is the following. As we discussed, maritime liens are a secret form of security, so they only truly materialize when the maritime lien is being enforced, when the ship is being arrested and the maritime lien is being enforced. And outside of insolvency, ship owners, ship financiers interested in the maritime industry are well aware of this exposure to secret maritime liens that they are facing. So generally, they are highly insured against this risk through specific marine insurance mechanisms, P&I insurance of ship owners, quite over the board, insure maritime lien claims. The insurance, however, can only be triggered from the moment that the maritime lien is being enforced. This, within the context of the secret maritime lien, also makes sense. Only when the maritime lien is being enforced is this insurance covered, is this insurance triggered. So this would essentially lead to maritime liens being satisfied by a different pie, let's say. So thanks to this insurance, maritime liens would leave the insolvency estate and leave a bigger pie for the ship financiers and the debtor alike, and at the same time also allow the ship to continue on its voyages, to continue to generate revenue, and in this way also maximize the value and increase the chances of restructuring efforts.
Thank you, Warren. So, Kayun, we would love for you to weigh in on this discussion as well. And in particular, what would be some of the practical difficulties with implementing any carve out from the moratorium protection for maritime claims?
Thank you. So yes, as Mike had earlier alluded to, Singapore is one of those countries that has a carve out for any creditor to commence, but not to continue any admiralty proceedings. So that means whether it's a maritime lien, statutory lien, so long as you want to take any action against a vessel, you can start that. Well, I have the lawmakers in audience today, so I can only speculate as to why this exception was crafted in the way that it was. But just from the very limited public information available, it seems to me that the underlying rationale is that in Admiralty, you can create a security interest just by filing a writ. So earlier Mike mentioned this Tucker fiction. We have the same story as well in Singapore, where the ship is treated as a separate legal person. So there is an old English case that is also followed in Singapore that's called the Re-Arrow Co. Limited. And in this case, it was actually a liquidation and a vessel that was already under arrest was about to be released. Then another creditor who was in that jurisdiction and who wanted to keep the vessel under arrest then said, "Can I have leave to proceed to keep this vessel under arrest?" So the words of that English court were that, well, you can assert as against the world that you have the right to arrest this vessel. So I'm giving you leave as if you are a secured creditor. So over the many years that this decision was handed down, it has been interpreted in many ways, and a lot of the maritime practitioners, surprise, surprise, have read it to mean that the moment you start proceedings, you are elevated to become a secured creditor. So you put all these pieces together, and in the context of a wide carve-out like Singapore has, what it means is that in a shipping insolvency, now that you have a carve-out, so all of your maritime creditors can start admiralty proceedings and as a result, elevate themselves to become a secured creditor. So, well, interestingly, we have an ongoing case before the Singapore Court of Appeal where they will tackle this issue head on whether the issuance of proceedings will be the creation of security. So I think in the US, from what Mike has shared, the creation of security really only happens upon attachment or upon an arrest. So this question is not yet settled in Singapore because we do have some people who read that particular case to mean that the institution of proceedings will make you a secured creditor. All you have to do is just pay $100 in Singapore currency and you are secure. You know, that's a pretty good deal, right? Yeah. So now the court will have to decide, is this something that you can allow? And again, we have another piece that I mentioned earlier, where you have sister ship arrests. So what this means is that I can name 50 ships, so long as they're all under the same ownership umbrella for the same claim. If I'm allowed to create security just by filing a writ with all of their names, I can actually enlarge my pool of secured assets. So again, these are some of the issues that we have raised to the Court of Appeal, and we are waiting a decision on that. So stay tuned.
Yeah. So I would be remiss if I didn't. You hear me?
Yes.
Okay. I would be remiss if I didn't interpose a collective remedial based alternative view of the world, which is that one of the fictions in our bankruptcy law is that when you file a case, you create a moment in time where you fix assets and liabilities, and you create an opportunity to enhance their value based upon contingent prerogatives that belong to the fiduciary that's running the case. And that means that you create a moment in time where you don't accelerate the creation of judicial or other liens by virtue of the operation of non-bankruptcy law. The idea is to stop in the rubric of the case law the race to the courthouse, right? And so fundamentally, the idea of creating a reorganization solution in particular, right? Like a lot of the rules that we're talking about here with respect to maritime liens and so on make sense when you're liquidating a vessel, okay? But when you're trying to reorganize a shipping business of which this one vessel is a part, it's critically important that you have a stay, a pause, a moratorium, an ability to look for other solutions to rehabilitate the business, whether it's through finance, whether it's through sale, whether it's through standalone reorganization, compelling holdouts. And you can't do that if you have critical assets subject to multi-layer chessboard litigations all around the world. So for example, in the US and in particular here in the Southern District of New York, there is a doctrine in ancillary proceedings that's developed where once a foreign main proceeding is recognized and its stay would otherwise have prevented an arrest or an attachment, the court post-recognition will order the vacatur of those maritime attachments or arrests in order to enable the international restructuring. There's multiple examples of that. I've litigated the issue myself. That is part of the tension. And when you're dealing with, at least in the United States, what I would view as the paramount restructuring law with this enormous related to jurisdiction, the fact of the matter is that you need to channel maritime liens and claims just as you need to do any other species of claim. And so the solutions that you need to come up with in these cases are various. Sometimes when you have vessels in an advanced stage of disposition, you use bar dates to create consent rights so that you enhance the power of bankruptcy courts, as we saw in the Millennium Sea Carriers case or in Delaware in the MUMA case before Judge Walrath. But I want to make certain that we have this contra perspective from the restructuring side, which I think most of the folks in this room identify with. And I know Qayyum may secretly identify with, notwithstanding the Singapore law. It's very, very hard to do bankruptcy right. It's the equivalent of emergency room surgery. And the more complicated the litigation picture surrounding the bankruptcy, the less likely it is to succeed in accomplishing a rehabilitation or reorganization of the business. And so I caution folks against embracing the idea of elevating the beautiful poetry of the Admiralty law and the fiction of the personified vessel, the image of the clipper ship in your mind, over the idea of saving jobs, rehabilitating vessels, putting them back into commerce, and getting the best result for the fulcrum stakeholders in any capital structure.
Yeah, I mean, I don't think it's that secret, but I'm with you on that. As in, I personally feel that when you have a carve-out allowing for vessel arrest, and for this specific industry, it is extremely difficult for any shipping debtors to seriously consider restructuring. And I think since the carve-out was legislated, we haven't had that downturn, as an industry-wide downturn. We haven't really tested the effect of that. But we did have one successful restructuring of a liner company. And how did we do that in that case? We simply, didn't have the vessels call into port. That's number one. You do it by the practical ways. You just don't let you have to bunker outside of port limits, or you have to get your financiers to support payment out to the trade creditors first, so that all of your tiny little claimants, but who have the nuclear weapon of being able to arrest your vessels, you have to take that away before any effective restructuring can happen. That's the only way that you can really restructure, when you have that carve out. So these are my 2 cents. But yes, our legislation is what it is. And we'll wait for the Court of Appeal decision, because I think if the security question is settled, that does change the landscape and maybe some of the thinking around how we want to continue treating our shipping companies. Because for Singapore, I think for most of you in this room, you would know that it is a huge, an important policy objective for Singapore to have a strong insolvency hub. But it is equally important for us to have an Admiralty hub. And I think Singapore tries to maintain its ranking as a leading maritime city. But to me, I think that having an effective restructuring regime when your shipping companies go down is just as important. We have to have that ability for them to come into the ER when they need to.
Very well, thank you so much to our panelists. I'm getting signals that we're out of time, but there was just one last topic of the Beijing Convention that we wanted to cover, and maybe Warren, you can take just a few minutes just to tell us about how the introduction of the Beijing Convention benefits the administration of maritime insolvency.
Okay. So the Beijing Convention is essentially, well, as the name says itself, a convention on the recognition of the effects of judicial sales of ships worldwide. So that would mean the recognition essentially of the effects of a court sale, that a maritime lien is, that the ship is scraped free and clear of maritime liens. So in my view, the Beijing Convention would be a great supplement to the existing framework of the model law, since the model law doesn't include any provisions on recognition of insolvency judgments and other sorts of court sales. The Beijing Convention would actually allow for the direct recognition, not only before courts, but directly in the ship registry, of the fact that a ship is that the ship has clean title, that the ship is free and clear of maritime liens. So it would be a nice and useful supplement to the model law on cross-border insolvency, but also to the more recent model law on insolvency-related judgments, because contrary to that model law, the Beijing Convention directly targets the effects of the court sale at the ship registry, so circumventing actually also further recognition procedures before a court.
I'm largely in favor of uniform outcomes when you get to the end of vessel foreclosure. So the Beijing Convention, I think, is very helpful development which you've adopted, would help create uniformity of results and outcomes, which would indirectly benefit the restructuring process. We also, as much as I have been playing the proponent of bankruptcy over all else, the admiralty law is almost always, it seems, in effect in connection with specific disputes involving vessels. And there is a very, very wide aperture within which its application takes place without regard to restructuring or bankruptcy. And in that context, it's important to remember my comment about the discharge of these liens. And really the most efficacious and notable way of discharging those liens is through a judicial sale. If you inject uniformity in outcomes through this convention, then you will enhance trade, which is fundamentally the goal behind both regimes.
Sorry, so just to add to that, my main message for the people in this room is that while the Beijing Convention was conceived in the context of maritime law, it is actually a really important tool for insolvency practitioners as well. And I'll give you an example of how we have utilized not the convention specifically, but how we had utilized the mechanism of a judicial sale in the judicial management in Singapore. So we were acting for the judicial managers of a debtor that owned about 80 over ships. It used to charter out these vessels to a trading arm and also a chartering company. But due to fraud that was done by these two companies, there were many writs that were filed on the vessels. So that meant that the vessels couldn't trade normally. They were always under and at risk of arrest whenever they visited those ports. And due to the nature of the business, many of these writs were concentrated in Singapore, Malaysia, and Hong Kong. So we spoke to one of the mortgagees, and they wanted to realize, obviously, the value of this vessel at one of the vessels at the highest price possible. So we then gave them some suggestions, and the one that they chose to go to, they chose in the end, was to sail the vessel all the way to Gibraltar, where what we call a private treaty judicial sale was available. And that meant that we could do the marketing first, and they could source a suitable buyer who was willing to pay X dollars, and then have it blessed by the court in Gibraltar. And then that allowed the wholesale to have the same effect of cleansing the vessel of all encumbrances. So it was also a very fast process. And I think the time for the mortgagee to get to the eventual money after the judicial sale was shortened by, I think, about 4 months. And the overall recovery that they had was about $4 million more, just by going to a different jurisdiction and using the judicial sale as a mechanism. So for the insolvency practitioners in the room, don't be restricted in your thinking that, okay, we can look at the model laws that we have for insolvency. There are other tools that could be available, industry specific ones. And in this case, the Beijing Convention is one such powerful tool that we can look at. There is, though, a conflict, I would think, because just looking at the provisions, while the vessel is under arrest, until the time the court makes a judicial sale order, technically, you can imagine that under our current model law, a foreign representative could get recognition. And under Article 21, you could seek an order for repatriation of that asset for distribution. So there are some existing areas of conflict that I think would still need to be resolved. But until then, if you can see the Beijing Convention as potentially adding to the assets just by having a much higher sale value, it could well resolve itself commercially, meaning that the foreign representative might not see it to be in the interest of the estate to block the judicial sale.
Right.
That's all I have.
Thank you all so much. So we'll stop here, and thank you to each of you for your expertise, for your insights. These issues are certainly so complex, and even though we're stopping here, I know there's a cocktail reception that follows. So if you have questions, please, our panelists will be available to answer your questions. Thank you.
I would say this is said at the conclusion of a lot of panels, but this was actually really fascinating. And this is I know UNCITRAL has been supportive of these panels on specific kind of areas of law, so that we can all kind of understand how what we're doing affects those. We at least know what we don't know, and know that there are issues out there. And I think this was very illustrative of that. So once again, really appreciate your time, you guys putting forth the effort. Drinks in the back, food out there, but let's thank our panelists once again.